A very good evening to all my dear students. Good evening, Soumya. Good evening, Almaz, Shailaja, Bhumika, Sunil Kumar. Welcome to the class on behalf of ICAI. I welcome each one of you for today's class. That is your third class on chapter number 3, Prospectus and Allotment of Securities. So we have done in the previous lecture, we started with the first lecture in which we did the definitions of security and the word prospectus. We have understood at length what is the meaning of prospectus, what are the contents of the prospectus. Section 26 tells us the entire detail, whether the prospectus has to be dated and signed, what all inclusions we have to make in the prospectus, what is the role of expert statements, everything in detail we have done about the initial part of prospectus. In the previous session, we have discussed about the types of prospectus. So I'm going to ask you questions today. We're going to have a quick recap. Let everyone join and then we'll start. Anurag, Simriti, Soumya, Vishal Chaudhary, all of you, good evening, children. A very warm welcome for the session. And those who have written, yes, ma'am, we have revised, Meera, Ritika, all those who have joined on the portal also, a very good evening to all of you. So we have done the initial part of the prospectus. After that, we discussed about section number 27, how the variations happens in the prospectus. Then it was a point. Yes, great. Those who have written, yes, ma'am, we have revised. So that's great. Somebody has written a query also. Insurance is made. Yes, Bhumika, if you're giving any kind of security for the goods, it will be counted as a security. But here we are talking about the shares as a security. So you are not subscribing for the securities over there if you're using the word security. That is related to your chapter of charges. All right, Bhumika. Good evening, Priyanka. Good evening, all of you. So we have done in detail about the definitions, about the types of prospectus. So what were the 4 types of prospectus that we have discussed in the class? Quickly tell me, meanwhile others are just joining the class. What are the 4 types of prospectus that we have done in the class? Who is going to tell me? So I'm sure you have revised the content from the study material also. You have revised each and everything. Samriti says deemed prospectus, shelf prospectus, red herring, and Rajveer, Julie saying it is abridged prospectus. Excellent. So all of you remember we have discussed in the first lecture about section 23 and 24 also, where we talked in detail about public offer and private placement. So starting with the revision for first part, because I always prefer to start my class with a quick recap so that the students remember what we have done. So we have elaborated the definition of prospectus in the last class also. There are 4 types of prospectus. 2 of them are included in the name, in the definition of the word prospectus itself, which says that it is any document by which the public company is going to the public and inviting the subscriptions. It includes shelf prospectus, red herring prospectus, and any advertisement or notice which offers the securities from the public. Wherever you are inviting the offers from the public, it is known as prospectus. So my first question to the class is there any difference between deemed prospectus and offer for sale of securities? Okay, Mr. Kevin, I've read your doubt. I will explain you when we will be revising misstatement. So in the previous session, we have done section 34, 35 also. So we will be having a quick recap of that also. So Julie Singh says, yes, deemed prospectus and OFS are same. No, not at all. Yes, Priyanka, OFS is a sale done through, no, it is not done through issuing house. Deemed prospectus is where you're going to the issuing house. Yes, good, Priyanka, it's not the same. Rajveer saying, great. Yes, Bhumika. OFS is for existing holders. Very good, Julie Singh. OFS is where the existing shareholder goes to the company that please sell my shares in the market. But deemed prospectus is where company is going to the issuing house and requesting them to sell their shares in the market. So both of them are different. Both of them are different, but you have to understand what is the structure of both of them. In deemed prospectus, company is going to the issuing house, but the document that the issuing house uses for selling the securities to the public shall deem to be the prospectus. In the same way, offer for security, when the existing shareholder goes to the company and asks them that please sell my shares in the market, again, the document that the company will be using shall deem to be the prospectus. That's why we tell you in the beginning of the session that public company can raise money by way of IPO, FPO, and OFS. That's why OFS is included as a way of offering the securities to the public, although the share pattern is not only the share pattern is changing, the total shareholding is not changed in OFS. All right, the next question for the quiz goes to the class. In case of rights issue and bonus issue, is there any requirement for issuing the prospectus? Yes, ma'am, or no, ma'am? For the rights issue and bonus issue, are we issuing the prospectus? So public company is raising money through prospectus only in case of IPO, FPO, and OFS. And yes, absolutely correct. Why there is no need? Because here we are issuing the prospectus to our own. We are asking the existing members, so there is no need. They already have the knowledge about the prospectus. So what were the two cases in which, okay, first of all, the question from section 26, because I did not take your test from section 26 of the previous lecture. We did revise 27, 28, and we did section 30 to 34 in the previous class, 35. So let's have a quick recap of section 26 also. What are the 5 important reports that needs to be included? So one is the declaration, which tells you about the compliance. Another one, write down the 5 important information reports that are to be included in the prospectus as per section 26. Very good. One is the declaration, the statement that all the acts have been compliant. Third is all the reports, financial informations required by the SEBI, and then expert statements. All right. This one is very simple. You all know that. So the next question for the class is, what are the conditions? Yes, Shailaja, excellent. She has written, dated, and signed also. These are important 5 points you remember. Okay. So what are the 3 conditions to be satisfied whenever you want to include expert statement in the prospectus? What are the 3 conditions to be satisfied whenever you are issuing and adding the expert statement in the prospectus? Yes, Mausam Kumari, Kevin, I'm waiting for the answers. Very good, Kevin. Kevin has asked, ma'am, section 447, wrongful gain and loss once again, please. Okay, Kevin, we will take up that. Excellent answers given by Judy Singh, Rajveer Ray, Soumya. Not engaged in the formation of the company. Excellent. And he has given his written consent and he has not withdrawn his consent. If the expert consent is withdrawn, then it cannot be included in the prospectus. Shailaja and Bhumika has also given. Very good. Very nice, student. So this tells me that you have really revised your work very well, and revision is must. In CA intermediate, generally the students feel very scared considering that law is very huge. But only one thumb rule you all my students have to remember: if you are revising your content properly, if you are very thorough with the subject, then no one can stop you from winning this race. All right. And what's the definition of expert? We have done that number of times. So now you remember these are the exceptions where the prospectus is not required. And the last question to the class goes, who is going to sign the prospectus? Validity we revised in the previous class. So who is going to sign the prospectus? Not the deemed prospectus. I'm asking about the prospectus. All the directors, including the proposed director. Pura likha karo beta. You have written all directors as consent, including the proposed director, and even the attorney, duly authorized attorney, can also sign. So this is the correct answer. Every person who is named as a director or the proposed director in the prospectus, duly authorized attorney can also sign in his representative capacity. Is that clear, everyone? All right. After that, any doubts in section 27, 28, children? Very good, Kevin. I've seen your answers. Mausam Kumari, good answers. Any doubts in section 27? What was the form number which was to be used in which the advertisement is given for the variations? Tell me the form number. Name the form number in which, yes, he is a legal advisor, Bhumika. Absolutely correct. Attorney is the person, a lawyer who is having a certificate of practice. Very good. PAS1, not PSA. Julie saying PAS1 form is the advertisement of notice. Then we did OFS. Who is going to reimburse all the expenditures done in case of OFS? Will the company reimburse all the expenditures or the shareholder has to bear? Member is going to reimburse all the expenditure. Very good. Intelligent students in my class. Oh my God, Almas, Sanubhav, Priyanka, Bhumika, all of you are answering. Vishal, great. PS2, Kevin, that was wrong. PS2, I'm going to ask you now. And what were the exceptions to OFS? Minimum subscription, minimum application value. This is today what we are going to do in section 39. Section 29 was very simple. Only DMAT form to be used. Clear hai sabko? And section 30. Now the test starts. What are the contents to be used in the memorandum when we are giving the advertisement of the prospectus? Quickly tell me the 5 contents to be included in the memorandum of association as per section 30. Objects have to be mentioned, liability has to be mentioned, name of the signatories, number of shares, and the capital structure of the company. Everyone remembered section 30? So what was your shelf prospectus? Have we done these MCQs? Someone please tell me. Have we done these MCQs? Did we do these MCQs? I don't think we have done the MCQs. No, ma'am. Okay, Sunil Kumar says. So here is the first MCQ in front of you on the screen. An issuing house has issued an advertisement in 2 newspapers for the number of shares to be allotted under a private placement. In which of the conditions it will not be deemed to be a prospectus? So issuing house is a share broker. You have gone to the issuing house and they have given the advertisement in 2 leading newspapers for selling the number of shares allotted to it by a company. If the advertisement was given within 6 months from the date of allotment, if it was given after 6 months and the issuing house has received the entire consideration, issuing house did not pay the consideration till the date of allotment and the advertisement was given within 3 months from the date of allotment. What would be the correct answer? What would be the correct answer? Rajveer, Samriti, Julie saying absolutely correct. Almas correct. Students on the portal, Kevin wrong. Name of the signatories, okay, that is the correct answer. Mausam Kumari and Kevin has given correct answers for the previous question, but this is wrong. Soumya saying C, oh my God, all correct. Ananduri, A is not correct answer. Read the question very carefully. When the advertisement shall not deem to be the prospectus. So the advertisement shall deem to be the prospectus if it was given within 6 months of the allotment, and or the second condition is issuing house has not received the entire consideration. So here this 3 months and 6 months condition is not falling for not deemed to be the prospectus. Issuing house did not pay the money till the date of allotment was not any kind of condition. So B is the correct answer because you have issued the securities after 6 months. So within 6 months agar hota to deemed prospectus hota beta. And the issuing house has paid the entire consideration. हमारे वाले में क्या था? If you have not received the consideration, then it shall deem to be prospectus. Are you understanding? Yes, Dhanush. Correct answer. Priyanka, correct. Soumya, Lodi, you have given wrong answer. There are 2 Soumyas in the class. So one has given, both of them has given the wrong answer. One is saying C, one is saying D. So both of them are incorrect. Please make sure that you read the question very carefully. Now, child, this question was given in a negative sense. क्या prospectus नहीं होगा? आपने ये पढ़ा था कि अगर ये 2 conditions satisfy होती हैं, then it is deemed to be prospectus. It says, as per section 25, allotment is made with an intention to be made public if OFS is made within 6 months or the date on which it has been made, whole consideration is not paid. अगर कंसिडरेशन ना पे करी गई हो और 6 मंथ्स में हो जाए तब वो प्रोस्पेक्टस मान लिया जाता। तो इसमें वो कह रहे हैं कब प्रोस्पेक्टस नहीं माना जाएगा। तो अगर ये दोनों कंडीशंस नहीं हो रही हैं तो दैट मीन्स ये दोनों ही नहीं पूरी हो रही ना। आप समझ रहे हो, 6 महीने में हो जाता तो यस मैम प्रोस्पेक्टस, 3 महीने में हो जाता तो यस मैम प्रोस्पेक्टस, कंसिडरेशन रिसीव नहीं होता तो मैम प्रोस्पेक्टस। तो ए सी एंड डी में तो प्रोस्पेक्टस हो रहा है, हम उसे मान रहे हैं डीम प्रोस्पेक्टस। सिर्फ बी ही ऐसी कंडीशन है कि अगर हम दोनों प्रिंसिपल अप्लाई करते हैं, दोनों में से कोई भी अप्लाई करते हैं तो उसे प्रोस्पेक्टस नहीं माना जाए। क्लियर? Nice brainstorming question. Yes, Soumya, now got it. Good. Anubhav, correct answer. Very. So many of you have given the correct answers. Great. And I've given you the hint also that it relates to section 25. Okay. A private company security by right issue, by bonus issue, by private placement, or by issue of prospectus in public. Second question. What is the correct answer? Very good. Everyone has given the correct answer. D is the correct answer. Good. So only private company is prohibited from making public offer. It can go for right, bonus, and private placement. Okay. In case of offer of sale of securities by certain members, which option is applicable? The provisions related to minimum subscription is not applicable. Entire minimum subscription is to be received within 3 days. Entire money to be received within 3 days. 25% of the minimum subscription is required to be received on the opening and 75% within 3 days. 50% of the minimum subscription is required to be received by the second day and remaining. So what is the case in case of OFS? What is the case in case of OFS? That whenever there is an OFS, which option is applicable? Think very carefully and answer me. It's a very easy question. Something has been given to confuse you. Ananya, Anubhav, Soumya, Ayush, Sinha Chauhan, great. Samriti, all of you have given the correct answer. Wonderful. Ritika, Kevin, Harshada, Saroj, very good. Excellent. Julie saying wrong answer. Priyanka, wrong answer. I don't know why you are saying B and C. So absolutely correct. First part is the correct answer. Minimum subscription is not applicable. क्या मैंने आपको कुछ भी ऐसा पढ़ाया है कि 25% होना चाहिए, 50% होना चाहिए? आप मुझे ये बताओ, क्या हमने पिछले दो अनुभव से नो मैम नेवर। सो फिर जब ऐसा कुछ था ही नहीं, सो आप क्यों उसमें माइंड अप्लाई करोगे? नाउ दिस इज अ वेरी इंपॉर्टेंट थिंग टू टेल यू चिल्ड्रन. MCQs which will come in exam will be totally related to these kind of questions which I'm doing with you, because yes, we tend to confuse you so that you can apply your mind. Conceptual clarity is very easy. Now those who have written, ma'am, it's very easy, I'm so happy to read that, because you have now understood the concept. The students who are still making the mistakes, it's absolutely normal to make mistakes. I'm glad you can make the mistakes in my class so that you don't make the mistakes in the actual final day. And that is how we learn, right? Now, Mausam Kumari is saying, ma'am, can you explain offer of shares again? पूरा OFS again, पूरा दोबारा से. हाँ, मौसम कुमारी क्या नहीं समझ आया उसमें, जल्दी बताओ. Offer of shares means when the shareholder goes to the company and tells him that please sell my shares in the market, and company sells his shares to the public. Whatever expenditure is incurred by the company, that needs to be reimbursed by the members. And after that, there are four things. After that, there are four things that is not applicable to OFS. Yes, Mosam, these questions are making our concepts more clear. Soumya says that. That's great. Yes, Mosam, what do you want to ask?
मैम ये जो क्वेश्चन था ना, उसका जो शेयर्स परसेंटेज में दिया हुआ था ना, वो नहीं समझ में आ रहा था.
ओके, आपको हिंदी में समझा दूं?
ओके मैम.
ओके, सो बेटा ओएफएस में ना आपको मिनिमम सब्सक्रिप्शन, आपने 4 पॉइंट्स पढ़े थे ना कि 4 चीजें एप्लीकेबल नहीं है, मिनिमम सब्सक्रिप्शन, मिनिमम एप्लीकेशन मनी, एंड यस सुनील कुमार, गुड, दे आर राइटिंग इन द आंसर्स, यूटिलाइजेशन रिपोर्ट एंड व्हाट यू कैन नॉट गिव। तो वो 4 चीजें एप्लीकेबल ही नहीं है। तो जब एप्लीकेबल ही नहीं है तो ये सिर्फ आपको कंफ्यूज करने के लिए दिया हुआ है, 25%
और
आ
मैं
गया,
इसीलिए
75।
मैं कंफ्यूज थी।
तो तभी तो दिया था बेटा ये, सो दैट यू अंडरस्टैंड। तो पहली प्रोविजन क्लियर कट है। अच्छा,
हम्म।
इससे मैं आपको एक थंब रूल बताती हूँ सभी बच्चों को, व्हाट यू हैव टू
हम्म।
डू फॉर द एमसीक्यूज। जब भी आप सीए इंटरमीडिएट के पेपर में, लॉ के क्वेश्चन पेपर में एमसीक्यू देखते हो, सो आपने एमसीक्यू देखने से आपने, यू हैव टू रीड द एमसीक्यू एंड क्लोज योर आईज एंड थिंक व्हाट शुड बी द करेक्ट आंसर after. For example, this MCQ I read, in case of offer for sale of shares by certain, which option, तो ऑफर फॉर सेल में क्या क्या था जो नहीं एप्लीकेबल होता था, एक्सेप्शंस क्या थे। अब मैंने अपने दिमाग में सोच लिया वो 4 पॉइंट्स, मिनिमम एप्लीकेशन, मिनिमम सब्सक्रिप्शन, यूटिलाइजेशन रिपोर्ट, एंड द फोर्थ इज समथिंग व्हिच कैन नॉट बी गिवन इज जस्टिफाइड। सो नाउ आई नो दैट दीज 4 थिंग्स आर नॉट एप्लीकेबल, एंड मुझे स्टोरी भी पता है कि उसका भी शेयर्स कंपनी को देकर आगे बेचते। अब मैंने जब ऑप्शंस पढ़ी तो मैंने देखा कि ये 3 ऑप्शंस बी सी एंड डी से तो कुछ है ही नहीं, तो इसका आंसर बनता है। Are you getting it now?
यस मैम।
It's not at all there. So what will be the correct option? A. So when I have given signals to my brain that this should be the correct answer, and then I read the options, I will never get confused. But what my dear students actually do in the paper, they read the question and quickly jump to the answers कि देखते हैं कौन सा पार्ट ठीक है।
मैम मुझे ना ये कंफ्यूजन आया था कि शायद मैं कोई मिस तो नहीं कर दी, मैम ने कोई परसेंटेज वाला कॉन्सेप्ट तो नहीं करा दिया। तो इस
Yes, yes.
कंफ्यूजन
That's why I asked you specifically that there was no such concept. Okay, now Mosam, just mute yourself. Otherwise, everyone is going to raise their hands, and I'm not going
मैम।
to permit them. Okay, just mute yourself. All right. So everybody is clear now. And what mistake children generally you do is that you read the question and you start reading the answers, because we have this habit of doing it as we used to do for our English question paper. जब हमें comprehension आता था, याद है आपको, तो हम paragraph में से answers ढूंढते थे. So that is how we used to do. But here the questions will be a little tricky, so you have to be very careful. All right, there is another question for all of you. A company was incorporated on 2nd December 2018 with 25 subscribers, and the authorized share capital is 50 lakh. The directors are in a dilemma whether to issue share certificates in a physical form or a demat form. So I give you 2 minutes. Read the question very carefully and answer me the correct option. Everybody will read it very carefully and then answer me. Is it something for unlisted? Being an unlisted company, it can issue the physical shares, demat. Company have 100 shareholders, needs to issue the shares in demat form. Company needs to issue the shares only in dematerialized form. What is the correct option? Again, it's a very simple question. How to read more pages in limited time. Okay, Bhumika, we will discuss these tips at the end. Thank you, Priyanka. I'm glad you're finding these questions at the examination experience. That's great. Good, Anubhav. Everyone has given the correct answer, but Anubhav and Julie Singh and Bhumika somehow have given the wrong answer. Rajveer Ray, your answer is correct. Kirubha, your answer is correct. Saroj, Ayush, Elmas, your answer is correct. Sunil Kumar, your answer is correct. So what are they talking about? 2nd December 2018, something which I told you in the previous class. I have not revised one section with you, but I have given you the hint, section 29. What does section 29 tells you? Quickly tell me. that the shares have to be subscribed and issued in the dematerialized form. So simple, company needs to issue the shares to the subscriber only in dematerialized form. Being an unlisted company, it can issue in physical securities or issue them. But what was the provision? UPC, unlisted public company के लिए तो आया था section 29, that now you have to do it in the dematerialized form. Now, what happened to this? So everyone has got the answer. Again, A part was to confuse you because children will think that it is unlisted company. तो हो सकता है ये हो या ना हो. But हमने 29 section में clearly पढ़ा था that every company which is making the public offer shall only issue the securities in dematerialized form. I also told you that there is rule 9 and 9A, which is not part of your study material, but still we tried to have a fair reading from the website notes that we have taken related to that rule. Everyone is clear about this? Now, last question. A shelf prospectus filed with ROCL will be valid for a period of 1 year from the date of registration, 1 year from the date of closing of the first issue, 1 year from the date of opening of the first issue, or 90 days from the date on which it is offered. So, a shelf prospectus which is filed with the ROC is valid for how long? A shelf prospectus which is filed with ROC is valid for how long? 1 year from the, okay, you all know 90 days का तो नहीं है, तो पहले 3 में कुछ आंसर छुपा हुआ है, because shelf prospectus is valid for 1 year. From date of registration तो कुछ भी नहीं होता था, from कौन सी registration? From the closing of the first issue or opening of the first issue? Apply your minds between B and C. I've given you a hint. Soumya, Sunil, Anubhav, Rajveer, Shailaja have gone for C part. So A and जो D कह रहे हैं वो तो बिल्कुल ही गलत है. ठीक है? Okay, Saroj, Bhumika, Bhavya. So from the opening of the first issue is the correct answer. The shelf prospectus filed will remain valid from the 1 year from the date of opening of the first issue. Now, the second question is, what is RHP? Red herring prospectus? Within how many days the red herring prospectus has to be issued before the first offer of securities? RHP is issued within, oh, very good. So many correct answers, even without letting me complete the question. Excellent. 3 days. Wow, what is 1 month? See, look, Samriti is, I think, confused with information memorandum. वो information memorandum था 1 month. I know that there are so many things. That's why we are revising, children. 3 days, Almas and Priyanka have given absolute correct answer. Dhanush says 90 days. 90 days was only the validity period of prospectus. Okay? Everybody now can recall 3 days prior to issue of the securities, RHP has to be issued. Now, the next question is, true or false? Is RHP a full prospectus? True or false? क्या RHP रेड हेरिंग prospectus एक full prospectus है? Very good, Meera, Shinoy, Kevin, Ritika, all those who are answering here. Naveen Kumar, great. Harshada, many students at the portal also today. Good. Excellent. And Shelja has written, no, ma'am, because the quantum and tries are not included. Very good. Soumya, Anurag, so many of students have given the correct answer. False is the correct answer. So this was your last MCQ. Is RHP a complete prospectus? So answer is false. Correct answer is false. Enjoyed the MCQs, everyone? Was it nice, fun to revise it through the MCQs? All right, good. Now we will have a quick recap of types of prospectus. Although you remember all these prospectus, deemed prospectus section 25 है, हम बहुत बारी कर चुके हैं, अब दोबारा नहीं करेंगे. फटाफट से मुझे बता दो, what is the meaning of shelf prospectus? What is the meaning of shelf prospectus? Who is going to explain? Okay, anyone would like to raise their hand and explain what is the meaning of shelf prospectus? A quick recap. Okay, thank you so much. All those who have written, ma'am, it was a good recap and revision. Thank you, Soumya. Issued in one or more issues. Okay, who is going to explain what is the meaning of shelf prospectus in 2-3 lines? Anyone can raise their hands. I will try to unmute you. All right. Yes, friend.
गुड इवनिंग मैम।
Good evening.
मैम सेल्फ प्रोस्पेक्टस जो है हम 1 ईयर के पीरियड में इशू करते हैं, हमें ये बार बार इशू ना करना पड़े इसलिए हम 1 मंथ के बाद इंफॉर्मेशन मेमोरेंडम इशू करते हैं। और सेल्फ प्रोस्पेक्टस में हमारे ऑब्जेक्ट्स होते हैं और डिटेल्स होती है 1 ईयर में हम क्या क्या चीजों में हम मनी को यूज करेंगे। और इन केस अगर कुछ बीच में हमारे ट्रांजेक्शन में कुछ डिटेल्स मिस हो जाती है या फिर कुछ प्रोजेक्ट हम चेंज करना चाहते हैं, अगर डिसेंटिंग शेयर होल्डर्स अपना पैसा विड्रॉ करना चाहते हैं तो हम उन्हें ऑफर भी दे मतलब ऑप्शन भी देते हैं कि वो विड्रॉ कर सकते हैं और उनके पैसे को हम 15 डेज में हम रिफंड कर देते हैं।
Okay, very well tried, Priyanka. Excellent. I'm glad आपने first time class लगाई. पिछली बारी पहली बारी shelf prospectus सुना है. And yes, there was little bit mistakes, but I'm happy you have tried answering it. So well done. So the correct words that you have to use it, shelf prospectus is issued for 1 year so that you don't have to issue the prospectus again and again. So the first word that you should come in your mind is when you're having multiple issues. A company which is coming up with multiple issues. Okay. So for the second mistake was where you said that 1 month before it has to issue prospectus. No, it has to issue information memorandum 1 month prior to the fresh issue. Okay. So very well done. Good, Priyanka. So whatever you have to tell with the information memorandum is, she nicely told you that whatever changes जो भी हुए हैं वो आपने information memorandum के through बताने हैं. And what is the form number of information memorandum? Let's see who answers first in the chat box. What is the form number for the PS2? Bhumika. Well done. Samriti, Anubhav, Rajveer, Shelja, सबने बता दिया. And अगर आपका शेल्फ प्रोस्पेक्टस इशू होता है, इंफॉर्मेशन मेमोरेंडम PS2 आता है, and if somebody feels that they're not happy with the material facts and changes in the business, they can withdraw their application and within 15 days. This is also a good point highlighted by Priyanka, that within 15 days the money has to be returned. Excellent. And information memorandum shall deem to be the part of prospectus. Very good. I think we have done these theory questions last time, practical questions. What is the red herring prospectus? One in which the price and quantity is missing, and you have also answered me within 3 days. So what was the last point? When's the final prospectus come? What needs to be disclosed and highlighted in the main prospectus? What was that? Red herring prospectus has the same obligation as prospectus. Any variation, कुछ भी दोनों prospectus में changes आए हैं, they shall be highlighted as a variation in the main prospectus. And second point, these variations have to be filed with ROC and SEP. Shelja, Anubhav, and Simriti and Soumya, good. Okay, Meera and Kevin has also given the correct answers. Well done. Clear? Any doubts in red herring prospectus? What is the method of price known as? The price method that we use for determining the price discovery method. What is that called? Book building method. Qualified institutional investors are given the prospectus. They are the experts in the field of stock market and they know what kind of quotations they will get. So they help us in determining the price, and red herring is used only at the time of IPO in order to find out the price of security. What was the abridged prospectus? Everyone remember? Salient features? 3 exceptions were there whenever you're giving the abridged prospectus. That is a summary of the prospectus. What were the 3 exceptions? Anyone would like to raise their hands and answer me the 3 exceptions of the abridged prospectus? Quickly. Okay, Bhumika's turn. Yes, Bhumika.
Yes, ma'am. Good evening.
Good evening.
Hello.
Yes, good evening.
Ma'am, there are 3 exceptions for abridged prospectus. First one is if we are issuing shares for underwriters And second one is if we are issuing debentures or debt securities, or if we are issuing new shares for existing members.
Excellent. Very good, Bhumika. So with
If
every share application form,
if other than we have made any default to give any abridged prospectus to other public, then we have to bear penalty.
what is the penalty?
It's 50,000 for each.
50,000 for each share
For
application.
each company and also officer in default.
Very good. Very good. So 50,000 rupees is the liability for the company for each default. So that example that I took in the previous class was depending upon the number of share application forms in which you have not attached. So you'll multiply the penalty with that number. Clear, everyone? Excellent. Everyone has given the correct answers in the chat box also. So good. Now, let's have a quick recap of misstatement and prospectus also. So we have discussed in detail about the criminal and civil liability, section 34 and section 35. So I'm going to ask you questions that when the prospectus contains the untrue statement or any material facts have been suppressed. So when we try to hide the material facts, material information about the certain things which is infecting the decision of the investors, then it gets attracted under section 34, a misstatement is said to have occurred. So there was a case study that I shared with you in the last class. Quickly answer me if any company has not given the name of its group companies like associate companies. Can we say that the prospectus is misleading? Yes, ma'am, or no, ma'am? Will section 34 become applicable? Yes, ma'am, criminal liability will become applicable. Absolutely correct. Another question to all of you, which I gave you as a homework that you should study from the study material. Let me find out. Now I'm going to ask you a new case study. There was a company which is paying dividend for last 5 years to its shareholders out of the profits. Company generally pay the dividends out of the profits. But this is what they have written in the prospectus, that we are paying dividend to our shareholders from last 5 years, but actually the dividends were not being paid out of the profits. Company was having huge accumulated losses and they were using their reserves and surpluses in order to pay out the dividends. So company, yes, was paying out the dividends, but it was not paying the dividends out of the profits. It was having losses. Yes, excellent, Kevin. The name of the case law also, you remember, Rex and Kaisland. That is absolutely correct. So can you say liability gets attracted over here? Will you call it a misstatement in the prospectus? It's absolutely misleading because you're making a false statement. It's the clear-cut case of making false statement. You are making statements which are material information. You have to tell the investors it is misleading. Liability becomes applicable. Absolutely correct. So what kind of liability becomes applicable? What kind of liability? Those who are asking, ma'am, where is this case? No, self-prospectus go. Sumanshi, you can refer to the recording of the lecture for share prospectus. We have already revised that, child. If you have any specific query, you can ask that. All right, let me show you these case studies because we were about to read the content from the study material in the last class also. So these are the cases which we have discussed. So it says misleading through false statements. If there is any directors and friends have subscribed to the large portion of the capital and they offer to the public the remaining shares, directors subscribed only 10 shares, it was held the statement is misleading. So where there are prima facie facts that you're using, in Henderson case, you were using the false statement clear cut. Okay, that my friends have taken this capital, you should also take. So you're using a false statement. By hiding the truth through superficial statement, matlab aap chupa rahe. Company is saying that we are paying dividends, but actually the company is incurring losses. They have written back some of the past provisions. It was held prospectus does not disclose the true and correct picture. मतलब आप सरासर छुपा रहे हो ना, profits है नहीं है, losses हैं और आप झूठ लिख रहे हो उसमें कि मेरे पास profits हैं. You are trying to hide the facts. So if you're doing such kind of things, then it will be, you will become liable under section 447 gets attracted. There was another case, ambiguous statements. What is the meaning of ambiguous? जो आपको पता है कि false है, जिसका कोई meaning नहीं, correct meaning नहीं निकल कर आ रहा, still you are using these kind of statements. You're saying the present value of turnover is 1 million pounds sterling per annum. The statement was true only if production capacity is considered, but untrue if it is the present production capacity utilization. So the statement which the directors knew may bear multiple meanings, which can be false. So it is misleading. मतलब मुझे खुद, मैं डायरेक्टर हूँ कंपनी की, मुझे नहीं पता ये सच है या नहीं, तो दैट मीन्स अगर मुझे ही नहीं पता है, आई एम इन अ डाउट, देन इट कैन लीड टू क्रिमिनल लायबिलिटी अंडर सेक्शन 34. So if there is any kind of statements which are true, not true, which are false, which are misleading, which are not in the form in which it should have been included, and it is a material information, then you come under the purview of 447. What are the remedies for the misrepresentation? Now here was the word related to misrepresentation. वो कहते हैं गलती से mistake हो गया हमसे, misrepresentation हो. Then what will happen? Then what will happen? That means you were not trying to make a mistake, but you have misrepresented. Law says all your Indian Contract Act will come into picture. If prospectus contain any false statement or disclose a fact which is misrepresentation, then the aggrieved shareholder has the following remedies. Remedies means solution. What action? यहाँ पे side पे table पे लिख लो. What action the shareholders can take? What actions the shareholders can take? Shareholders means जिसने उस prospectus के base पे invest करा है, company में shares खरीदे. What action they can take against the company? Number one is rescission or damages. What is the meaning of the word rescission? Rescission means to resign the contract, means to end the contract. Contract को voidable मान लिया जाए. या तो आप मेरी payment वापस कर दो, I am taking an action, I am ending the contract, or you go by the contract, whatever is written over there. And second thing is you can claim the damages. What is the meaning of damages? Can anyone tell me? A compensation that needs to be paid to the aggrieved party, which is as per your section 75 of the Indian Contract Act. Here your Indian Contract Act become applicable. It says damages and disease are not satisfied specified under Companies Act because they are available under the Indian Contract Act. वो आपको बता रहा है कि हमने आपको CA फाउंडेशन में इंडियन कॉन्ट्रैक्ट एक्ट पढ़ा दिया था ना, इसीलिए सबसे पहला बेसिक एक्ट जो हम लॉ में पढ़ते हैं फाउंडेशन में, which lays the foundation of our law subjectives, that is Indian Contract Act, because major agreements, major contracts are the law where the law implications come. So after Contract Act, we have sale of goods, जो भी Indian Contract से निकल कर आया. Partnership is also earlier part of Indian Contract Act, now separate act. So all this we have already studied. Then the huge Company Act come. So in Companies Act, they're not again mentioning about the damages because they've already mentioned about these things under the Indian contract. Since remedies are alternative courses, some of the remedies are not available. So you have to decide what remedy you want to use. Against the company and other civil liability, that means compensation to be used, and any person who authorized the issue of prospectus, usko kya liable ho jayega? Criminal liability and damages for the receipt. Criminal liability कौन सी है आपकी? Section 447 becomes applicable. So it says claim for compensation under 35. 35 civil liability की बात करता है, shall not be moved simultaneously for the claim of damages. So it has to be seen very carefully. The case needs to be analyzed. Say, for example, children, I told you in the previous class, if the misstatement is not of material nature, like my name, I'm a director, my name was having spelling mistakes. It was spelled instead of HARLEEN, you have spelled HARL single EN. Double E की जगह आपने single E डाल दिया. That means there is a spelling mistake. Now, if there is another director or promoter who is having a big shot and there is a similar name, then it can be a problem. But if such kind of mistakes, I am having my registered office in Delhi, I have not told them about another branch office, they're not very material mistakes. Then you cannot get the charge of criminal liability. And plus, you have the reasonable grounds to believe that the information was true and fair. Then also you can have an escape. So those defenses that I have taught you in the last class, they're very important to remember. Dhanush, recession means to end the contract. Yes, absolutely. Both the cases 447 will be applicable, Priyanka. Section 34 talks about your criminal liability and section 35 talks about your civil liability. All right, nice, Bhumika. Yes, it is absolutely a beautiful act of law, the Indian Contract Act, because it defines each and everything in detail. So it says a person who has purchased the shares from the company जिसमें untrue statement था वही apply कर सकते हैं for rescission. Now, children, tell me, there was Mr. A who did not apply for the shares, who did not invest in the company. उसने देखा prospectus misleading. Prospectus में कुछ गड़बड़ है. Prospectus was having a misstatement, but he did not buy the shares in that company. Can he file a case against that company? Yes, ma'am, or no, ma'am? Absolutely no. Why? Because he has not suffered any damages. In fact, he has not even taken the shares in a company. So he cannot. Shares taken becomes voidable at the option of subscriber. Now, this is again very simple. Voidable means you can either treat the contract end or it remains valid until it has been ended. If the court accepts his application of repudiation, then the company will remove his name and return his money. Now, again, let's take the same example, Mr. A. In the first example, he was not taking the shares, so he cannot resign the contract. In the second example, I'm going to tell you that yes, Mr. A has taken 100 shares in a company. Now he comes to know that it is the contract. See, children, whenever you're taking up a shares in a company, you're entering into a contract with the company. कंपनी ने आपको शेयर्स दिए, आपने कंपनी को पैसा दिया, शेयर्स एंड मनी एक्सचेंज हुआ एंड आपका कंपनी के साथ कॉन्ट्रैक्ट साइन हो गया. आप कंपनी के रजिस्टर ऑफ मेंबर्स में भी अपना नाम ऐड करा सकते हो. एक होता है शेयर होल्डर बनना. जब मैंने कंपनी में इन्वेस्ट करा, मैं कंपनी की शेयर होल्डर बन गई. But for becoming the member of a company, chapter number 1 preliminary, remember definitions? आज पढ़ लेना, उसको रिवाइज करना दोबारा. What was the definition that I've told you about shareholder and member? For becoming a member of the company, your name needs to be added in the register of members. Now, Mr. A has taken up 100 shares in the company. So he became the shareholders and he said that I want to become a member. His name was entered in the register of members. Now you have come to know that you are not happy with the prospectus. It has a misstatement. The company is not a good company. It has done something wrong. You have purchased the shares in the primary market in the IPO, and now you have come to know that the company is having a misleading shape. Now your contract will become voidable. Voidable के दो meaning होते थे. Contract either remains valid or you end the contract and claim the damages. So you will, if you want to end the contract, you will ask the court to remove your name and return your money. आपने 100 shares के लिए जो भी पैसा दिया था, वो company आपको interest के साथ लौटा देगी. And also, and as per section 75 of Indian Contract Act, आप damages भी claim कर सकते हैं. But when the rescission is not available, very important, very, very important. कब rescission available नहीं है? Right to rescind will not be available to the subsequent shares purchased from the market. Now, this Mr. A purchased 100 shares from IPO, that is in the primary market. And then later on, he sold the shares to Mr. B in the stock market, that is secondary market. Can Mr. B take an action against the company for rescission of the contract? All those who say why, no, ma'am, why no? Why no? Because, ma'am, only the purchaser from the primary market can take an action, not from the secondary market. Correct. Good. All of you have written the same. Great. Second part, a subscriber to the MOA cannot seek any relief as the company cannot be considered to be in existence at the time when he has signed the memorandum. He cannot said to have been influenced. If you are yourself a subscriber to the memorandum, that means you are part to the misleading statement. You have relied on an expert statement. Now you cannot take the relief of rescission. Let's make it more clear with the example. All the statements contained in the prospectus were literally true. It was written that the company has paid dividend for a number of years, but does not disclose that the dividend was paid out of capital profits and not out of trading profit. Allotment wants to avoid the contract, saying that the prospectus was false. वही वाली बात होगी ना, ये जो हमने case law में पढ़ा होगा. It's the same case law, this one. Rex versus Calcent. Rex versus Calcent में क्या हुआ था? आप dividend pay कर रहे हो, but you're not telling the company that you're paying the dividends out of the capital profits. That means आपके पास trading profits है ही नहीं. What is trading profits? Sale purchase of business से जो मुझे profit आया. What is capital profit? जो मेरा reserves and surplus में पड़ा हुआ है. So that means आपकी financial position अच्छी नहीं है. So non-disclosure of this fact is a concealment of material fact. Children, I request you to learn this legal language. This is how you have to write the answers in the exam. मैं आपको पढ़ा रही हूँ, सिंपल लैंग्वेज में समझा रही हूँ दैट यस देयर हैज बीन अ कंसीलमेंट, उसने गलती करी है कंपनी ने, ही कैन क्लेम द डैमेजेस. यू विल नॉट सिंपली गो एंड राइट वन लाइनर यस द कंपनी हैज डन अ मिस्टेक. नो, योर chartered accountant students, we expect you to write the answers in the way they should be written, and this habit gets developed by practicing the writing of the answers. So see beautifully, disclosure is a concealment of material fact because company is required to distribute the dividend from revenue profits. It can pay out of capital profits, but only under exceptional circumstances. So we believe that a material misrepresentation has been made. A lottee can avoid the contract. You can also add these lines that a lottee can either resign the contract and claim the damages. So actions can be taken against the company. He can avoid the contract. Everyone clear till here? All right. When to evoke? Statement of fraud, investors will get the right to take the action. This right is available even if the company has gone into liquidation. तो company अगर liquidation में भी चलेगी, it means company बंद भी होगी है, तब भी आप damages claim कर सकते हो. You can still claim the damages. But the misrepresentation should be of material fact. The person should have acted and suffered a damage. I explained you these points. These are related to section 35. Where it said that section 35 becomes applicable only if the company has actually issued the prospectus of misstatement and he has suffered the loss or damage. Again, every person, director and the authorized himself to be named as a prospectus will be held liable. Every promoter is liable. Remember in the previous class, we did a question in which I told you, evoke means that it will get applicable. Given it says, when does it get evoked means kab maan liya jayega. So this right is still available even when the company goes into liquidation. All right. So I told you in the previous class that if a director has, issued the prospectus, he relied on a promoter statement. So promoter himself is also owner of the company, right? Then also it will be considered as a false prospectus. Company will be liable to pay damages, means compensation. Now, this was very, very important. This is something which we were again doing. Exceptions to the liability. Kab aap liable nahi hote ho? When you have withdrawn the consent. So I am the director of the company, but before the prospectus was issued, I said, please, I have sent a public notice in the newspaper that I want to withdraw my consent. I am not happy with this company. I don't give my consent for the prospectus. Then will I be still held liable if the prospectus is misleading? No, ma'am. Good. If I am traveling to USA and the prospectus is issued without my knowledge and somebody has given my fake signatures, then I give a reasonable public notice that, look, whatever signatures have been given, they're not mine. Will I be held liable? No, ma'am. If I have relied on the expert statement, will I be held liable? No, ma'am. If I had reasonable grounds for believing that the statement was true, what example did I give you for this? Audit report. ऑडिट रिपोर्ट में लिखा है, मेरे पास रीजन है, ऑडिटर ने लिखा है तो मैंने सच मान लिया. अब ऑडिटर ही गलत लिख रहा है तो मुझे कैसे पता? सो मैंने तो रीजनेबल ग्राउंड दिया ना, मुझे रीजन देना. सी व्हेनेवर यू आर अ डिफेंडेंट यू हैव टू गिव द रीजंस इन योर फेवर दैट व्हाई यू आर डिफेंडिंग. डिफेंस इज वेरी इंपॉर्टेंट. ओके. And if the statement was a correct copy of the extract taken from the official document, again, this is your audit report actually, that you have taken it from the official document that in fact believed that it was true. So all these kind of statements you have to prove in the law that you are relying on a correct statement. Every person referred in subsection 1. Who is subsection 1? All these people. Every person, director, authorized person. ये बच्चे आपको अपने language में भी notes बनाने पड़ेंगे. I have given you the notes in the presentation, but you'll have to write all these notes handwritten also by yourself. So all these persons will become personally liable So what have we done in section 35? Section 35 says anyone who has subscribed the securities and it is a misleading prospectus, then if he has suffered loss and damage, then the directors become personally liable. Personally liable means without any limitation of liability. Any loss or damage has been incurred by the person who has subscribed. He has to prove that the prospectus was issued with an intention to defraud. उसको ये चीज प्रूव करनी पड़ेगी कि ये प्रोस्पेक्टस फ्रॉड करने के लिए इशू करा गया था, फ्रॉडुलेंट पर्पस के लिए. जब वो ये चीज प्रूव कर देगा तो डायरेक्टर्स की लायबिलिटी क्या बन जाएगी? पर्सनल लायबिलिटी. क्लियर? A prospectus was issued containing misstatement. When the fact regarding misstatement, one of the expert, Anilesh, who had earlier given his consent, gave a reasonable public notice that the prospectus was issued without his knowledge and consent. Can he escape from the liability? Tell me. It says any person, if you put the prospectus issued his knowledge, becoming aware he has given a reasonable public notice, therefore he will be covered under the exception. You don't need to remember the subsections. Only the understanding of the law is correct. Therefore, he can escape from the liability. I give you 1 minute. Read the question carefully. If you have any doubts, ask me. Meera Shinoy says, no, he cannot escape liability. Why? Yes, he can. Harshada, Rajita. All right. Clear, everyone? And what is criminal liability? This is criminal liability. हमने last time में कर ली थी. 34 ही सिर्फ pending था. तो sorry, 35 was pending. We have done 35 also in detail. What were the defenses for section 34? Number 1, if it is not material. And number 2, if you had reasonable grounds to believe that the issue of prospectus, when it was done, it was true and necessary. Now, there was another question which I want to do. A lottery of shares brought action against the director for the false statement. Director said that these statements were made by promoters. So I told you, director is saying that we are relying on the promoter. That is not an escape route. Yes, the director will be held liable. What are the requirements to claim the damages? The fraudulent misstatement has been made. You are the original lottery. What is the meaning of original lottery? Primary market or secondary market? Yes, Dhanush, he has given his consent earlier, but once he has withdrawn it with the public notice, then it's okay. Then he will not apply. Primary market, Rajveer Julie Singh, very good. Pavan Kumar, excellent. So when you are a primary market, you are buying the shares, then only you can claim the damages, but not from the secondary market. Peak versus Gurney, सबको याद है? कौन explain करेगा? What was the case law of Peak versus Gurney? (447) we will do today in detail again once we have done section 36 to 38. I think let's take a small break because we have done so much as of now. Soumya, deceit means? Deceit means that you're trying to cheat someone, okay? Yes, Priyanka, who is buying in the IPO is a primary market. That's correct. So, I hope you have got your answer. So, let's take a small break and then we will be completing section 36 to 38 and then we'll do section 39 also. All right, welcome back, students. If you have any doubts related to section 34 and 35, you can ask me. Otherwise, we are going to proceed for section 36. So I can see no doubts in the admin query. Also, Bhumika has written, if he has not purchased shares on the basis of prospectus, then BOD is also held liable for his damages. So he will not be held liable if they have not purchased the shares. All right. Even if the shareholder not bought the shares, still there will be any misstatement. So Samriti has also asked a similar question. If the shareholder has not bought the shares, that means you have not subscribed to the securities, then you will not be held liable. Then company will not be held liable. Okay, because अगर आपने कोई shares खरीदे और आपको नुकसान हुआ है, then only the directors can be held liable. Now there is another principle of endowed management which you have learned in the previous classes. What is endowed management? Something which is happening inside the company is not supposed to be known to the outsiders. So your company is doing any default, outsiders cannot be made liable for that. Okay. So if any resolution was to be passed, any board resolution, any SR to be passed for allotment of securities, if you are not doing that, again, investors will not be suffering because of that. So company can be held liable if the company has knowingly made any kind of false statement. Now, section number 34, 35, we have already done in detail, criminal and civil liability. Now, the section 36, 37, and 38 that we're going to do, all these 5 sections attract 447 penalty. So 447 is very, very important. And all these sections ultimately make the company liable for 447. So let us understand in detail what is section number 36. It says punishment for fraudulently inducing the persons to invest money. Here, you are not buying the shares on the basis of misleading prospectus. Here you are inducing another person. What is the meaning of induce करना? Encourage करना, provoke करना कि हाँ यार तू इस कंपनी के shares खरीद. It is very good company. When you yourself know that the company, influence karna, very good anubhav. So you're trying to influence the other person. So there was Mr. A who has a friend, Mr. B, and Mr. A read the prospectus of PQR Limited. Mr. A read the prospectus of PQR Limited and he found that there was a misleading prospectus. Mr. A know about this thing that prospectus of PQR Limited is misleading. If you are Mr. A and you have come to know that PQR Limited is having a misleading prospectus, will you invest in that company? Yes, ma'am, or no, ma'am? You will know. Very good. And now, if you are roaming with your friend Mr. D and you are not investing, but you are telling Mr. B, yeah, this is a very good company, you know, you must buy the shares of this company. You are making a reckless statement. Reckless means aise hi bol diya. You felt like saying and you are saying it, or you're knowingly saying any statement, any promise which is false, deceptive, misleading. You're deliberately hiding the material facts. Okay? You're inducing the other person to enter into a contract. Then any such agreement which you are making, Mr. A is making with Mr. B for sale and purchase of securities. या तो उसने वो सिक्योरिटीज खरीद ली और वो इंड्यूस कर रहा है कि अब तू भी उस सिक्योरिटीज को परचेज कर. नोइंगली ही इज ट्राइंग टू, हिंदी में कहते हैं हम उसको भी फंसाने की कोशिश कर रहे हैं. ठीक है. सो सेक्शन 36 is basically inducing the other person so that he invests his money and he also falls into a trap. So 447 will become liable if you try to do such kind of things. When you were small children, you could do these things. You are playing with your friends, you can bully them, you can induce them. But in the stock market, if you try to do any such kind of things, it is a fraud, which is punishable offense under section 447. So any such agreement, number one, for acquiring, disposing, or subscribing means for sale, purchase of securities, you're inducing the other person. Point number 2. Point number 2 says any agreement for the pretended purpose to secure a profit from anyone. So now, say for example, you know that your friend has a house in Delhi which is for 1 crore rupees. But you tell Mr. B that this house is for 20 crore rupees. You know, this is a very big house. It is for 20 crore rupees. You know something that it is not true and you're making a false statement so that your friend can have some gain out of it. So all these kind of statements where you're trying to give the profits to another parties. Again, for the stock market, you know that it is a misleading prospectus, but you're telling your friend that it's a good prospectus so that your another related party can earn profit out of that. So you want to secure a profit of any transactions related to the fluctuations in the market. Now you know that if the market rate, your friend purchase it for 10 rupees. Now the rate is 20. Otherwise, the prospectus is misleading. So you quickly tell your Mr. B that please go and purchase the security so that my friend can earn the profit of 10 rupees. So again, within purpose, you're securing the profits, and that is deceptive, false, misleading. And third is you want to make an agreement for obtaining any credit facilities from banks or financial institutions. You want that the person should take money from loans from the banks in order to invest in this prospect, in order to invest the securities, but it is a deceptive prospectus on the basis of which he is investing. So if you want to avail any kind of facilities, you want that the person should be taking money or loan from the banks. If you want any kind of credit facilities from the bank, so you're inducing the other person that why don't you take a loan from the bank and subscribe to the securities of this company, which you yourself knows is a deliberately concealing the material fact. So if any of these three things is done, either you're purchasing or sale of securities on the basis of misleading prospectus, you're inducing the person so that the other party can gain a profit out of the transactions, or you are trying to induce the another person to enter into a transaction so that you can take a credit facility from a bank or financial institution. Any of these three cases, you will fall under 447. ये सारी एग्रीमेंट्स इस प्रोस्पेक्टस पे बनी है जो कि फॉल्स है, मिसलीडिंग है, डिसेप्टिव है. You're trying to deliberately hide the facts. In all these three cases, you will be held liable under 447. So it's a very general section, not very important. Not important in the sense that it's not very detailed, but yes, he's an external party. How will Dhanush, he's not an external party. He is inducing the another person. So here, the case, the proof that we have to make is that it is because of him that I invested in the security. So he will have to make the proof of that. All the affected parties will take an action against these kind of things. Okay. So if you're buying and selling of securities, you're involving in a contract where you can earn secret profits, या फिर आपको किसी बैंक से पैसा लेना है, that's why you're inducing the other party that you should make such a kind of contract. In all these three cases, section 36, 447 will become liable. Clear? Now, what is section 37? Section 37 is again a very simple section. It says any case which is suit का मतलब क्या होता है? Suit file करना मतलब case file करना. Any case which is to be filed or action has to be taken in case of section 34 or 35 or 36 by any person. Means I am a person, Harleen ma'am suffers a loss because I am an investor. I invested in a on the basis of prospectus which was having misleading statement. So I am a person who has suffered a loss. Or I have suffered a civil liability. I have relied on a prospectus which is misleading and I want to claim damages against it. So again, I want to take an action. Or I'm a person who was induced by Mr. A that please buy the securities on this basis of misleading prospectus and I purchased the security. So I'm a sufferer under section 36. So either I have suffered because of section 34 or 35 or 36 and I'm one person, Mr. B. Or a group of persons, A, B, C, D, all these have suffered because of these sections. Or any association of persons. If they have been affected by any misleading statement or any kind of omission or inclusion that you have made in the prospectus, then we can file an action suit. Action suit का मतलब होता है class suit file कर सकते हैं. हम सब लोग इकट्ठे मिलकर एक action ले सकते हैं against that company. Like children, when Satyam fraud happened in back 2010, when Satyam was a very big company and the fraud occurred. So many investors had to suffer because of a single owner who has done a default. So if you are persons, if your different people are suffering because of any such kind of fault, then Section 37 has given the liability that instead of single person doing all the expenditure, going to the court and filing a case against the company, then all the investors will have to, go and file a case. So it says that it's better that you can file an action suit, means together all the affected persons can take an action against the company. It is also known as action suit that can be filed. So it is known as class action suit, which group of people try to file against the defendant. Who is a defendant? एक होता है plaintiff, एक होता है defendant. Doctrine of constructive notice, the other person should have read. Yes, Samriti, that's absolutely correct. But if it is a constructive notice, it is a public document. You are not reading it and you are falling under the trap of another person. So then Section 36 will definitely become applicable. Pavan Kumar, Section 34 में क्या नहीं समझ आया? You can specifically ask what you have not understood. Persons में individual is considered or HUF and company also, please specify. So Kevin, here we are talking about individual persons. Okay. In Section 38, we will be specifically talking about the company. All right. So what is the meaning of defendant and plaintiff against whom the case is being filed? Who is that? One who defends himself that I'm not liable. So he's a defendant. And the person who is filing the case, who is that? Guilty person is defendant. That's absolutely correct. But who is filing the case is known as plaintiff. That I am filing a case against another person. The other person is a defendant and plaintiff is filing the case. Excellent. All of you have given the correct answer now. So class action is a suit filed by group of people. So I was trying to explain you that there is a company ABC, and because of that company, 100 of investors suffered a loss. And they fell, say maybe under Section 34, 35 or 36, any of the sections, a group of persons or total association of persons has suffered a loss because of their misleading statement in the prospectus. Now they can file an action suit, means together a group of people can file a case against that company ABC because they have caused a common harm to the entire group. This is not like a common litigation method where one defendant files a case another while both the parties are available. So it is not a common method. Here, group is filing a case against one person. Group of people filing the case need not to be present in the case every time. So you will ask me, ma'am, then 100 investors will go every time and present their case. No, this is basically to save the cost. No? So only one of the person, a representative, can go and represent the case. Benefit is that several people have been injured. So each of the people will have to file the case separately. So it is better one single case can be filed against the defendant. So when Satyam case happened, so many investors suffered a loss and people were crying that we are the investors and now company's share price has fallen down. Company did a very big cheating. They did a fraud with everyone. And Section 37 was given to them that class action suit can be filed because the harm should be common. सबको एक ही तरह का नुकसान हुआ एक ही कंपनी से, तब आप Section 37 अप्लाई कर सकते हैं. So let's read. M applied for the shares of equity shares of a company on the basis of prospectus which contains misstatement. He has purchased the shares in IPO. That's great, right? The shares were allotted and afterward he transferred the shares to N. Can N file an action for the rescission on the ground of misstatement under Section 37? Tell me. Will Section 37 become applicable? Read this illustration and answer me in your own words. Is N buying the shares directly on the basis of primary market? Anubhav, so group of people who have come together are few individuals. Association is again an association of persons like you understand body of individuals, that kind of association which has suffered a loss. They're not exclusively using the word company. Very good. No is the correct answer because it is being purchased in the secondary market. So he cannot file an action for rescission because he's buying the grounds from M who has purchased because of misstatement. So Section 37 is not applicable. A suit can be filed if you're a sufferer under 34, 35 or 36 only by the person or group of persons who have been affected. So here, largely the group or association of persons is one and the same thing. Affected by any misleading statements. Therefore, M is eligible to file a suit. N cannot file a suit. Can M file an action? Yes, M can file an action. Correct. Everyone is clear about this? Section 36 also, we can see if there is any illustration. Section 36 में सिर्फ इतना ही लिखा है. A huge sum of money was collected under the document project overview by NRIs. But shares were not allotted in the proposed joint venture. Instead, the money was diverted to some offshore companies controlled by the accused person. Prima facie offense under Section 36 has been made out. So you are collecting the money by saying it's a project overview. Shares are not allotted in the proposed joint venture. You're trying to induce the people that it's a project overview. People are coming and they're giving their money, but you're diverting it to offshore companies by the accused person. So Section 36 gets applied. Now let's understand section number 38. Yes, Dhanush, it will be applicable for the case of Mr. M, not for Mr. N. That's correct, Dhanush. Section 37 is clear, 36 is clear. Where is section 38? Section 38, let's do from here because it's a very short section. Punishment for personation or acquisition of securities, section number 38. What is the meaning of personation? Personation. Using a fake name related to something which is related to securities for sale and purchase securities, you're using a fictitious name. Say, I am CA Harleen Kaur, but I buy the shares in the name of Anil Ambani. Am I Anil Ambani? My share application form is reading the name Anil Ambani. Am I Anil Ambani? No, I'm Harleen Kaur. So what have I done? I have done personation. There will be a penalty and punishment for personation. That means you're trying to cheat the law. You have used another person's a fictitious name you have given to the company. You're making the application in the name of someone else. You're pretending to be someone else. If you have made a fictitious name using the application, which is not your real name, then that is your first mistake under section 38. Yes, Kevin, that's correct. Ma'am, in that example, 34 will be applied right as it is for. Yes, Samriti, it's absolutely correct. Okay. Manish sir, are you there? From technical. Can you please remove Janvi B from the class? All right. So if there is a fake identity, yes, absolutely correct. If you're using a fictitious name, if you're making the application in a fictitious name for acquiring the securities, then that is the first case of personation. Second is you're making multiple applications in different names or using combinations of different names for acquiring securities. Then also it is the case of personation. So I'm making multiple applications. I'm using different names and combinations of different names. Again, you're trying to use a personation kind of information for acquiring the security. Now here, otherwise induces directly or indirectly a company to allot or register or transfer the shares in a fictitious name. Now here, a company is trying to cheat others. A company by a fictitious name, actually it is a company which is, manufacturer of rubber tires, but with the name of ABC Limited, but here it is allotting the securities by the name of Current Tires. So आप झूठा नाम ले रहे हो, fictitious नाम में आपने कंपनी बनाकर shares allot कर रहे हो and subscribe कर रहे हो. So law says in 3 cases where you're using a fictitious name for your share application, you're not the real name, it is a fake name. You're making a share application for that. Second, you're using a combination of different names. So first point के आगे लिख लो individually. First के आगे लिख लो individually where you are using different names. Second is the point of combinations. Combinations of different names if you are using. And third is the point of company is using a fake name for the allotment of securities. In all these cases, what penalty will get detracted, children? What section will become applicable? 447 will become applicable if you try to do any of these cases. So you're using different combinations of different fictitious name and making different applications. आपने इंडिविजुअली अनिल अंबानी का नाम यूज करा, आप ऐसे कोई और हो तो गलत सिक्योरिटी. फर्स्ट केस. सेकेंड इज यू यूजिंग द नेम ऑफ नीता अंबानी, यूजिंग द नेम ऑफ मुकेश अंबानी, डिफरेंट एप्लीकेशंस बना रहे हो, डिफरेंट नेम, अलग अलग नेम यूज कर रहे हो फॉर एक्वायरिंग द सिक्योरिटीज. गलत है. फेक नेम्स, मल्टीपल एप्लीकेशंस. Third is company is having a fake name for allotment of securities. In all these cases, 3 cases, penalty of 447 becomes applicable. So please write down over here any of the default under section 34, 35, 36, 37, and 38. 447 becomes applicable. In all these cases, 447 becomes applicable. In all these cases, 447 becomes applicable. Now, for this penalty 447, what is the precaution that the company has to take? Company will have to write in the prospectus that anyone who gives the false information or fictitious name will become liable to 447 with the clear application form. It is compulsory. This penalty of 447 is compulsory to be mentioned in every share application form. It says every company which is issuing the prospectus, it is prominently reproduce the provisions that every share application form should have this. So in simple language, you can write down. Please write down over here for subsection 2. Every share application form, the company should write and mention about this penalty of section 38. Company should mention about this penalty of section 38. That is, if anyone gives false information or fictitious name, if anyone who gives false information or fictitious name shall be liable to section 447 penalty. Shall be liable to section 447 penalty. Now, what are the consequences of this? What will happen? Now, third paragraph, first paragraph, we have written the notes that these are the 3 cases when section 38 becomes attracted. Second paragraph, subsection 2, all my students have written down. Share application form में ये penalty लिखनी है. What is the third paragraph trying to tell? What is the third paragraph? That is subsection 3. It says any person who has been convicted. Convicted का मतलब जिसको जेल हुई है, conviction हुई है जिसको, the court may order disgorgement of any gain made by such person. It includes seizure and disposal of securities also. And this disgorgement amount will be given to the IEPF account, that is Investor Education Protection Fund, जो हम chapter number 8 dividend में पढ़ते हैं इसके बारे में. अब मैम, what is the meaning of disgorgement? ये क्या word आ गया disgorgement? Disgorgement means to release everything out. Disgorgement means, please write down, it means to release everything out, to let out everything. Means whatever the gain this fictitious person has made by using this fictitious name, whatever gains or losses he has earned from the company, whatever profits he has earned, government is going to come and take all these profits and gains from this person. So there was a person, Mr. A, he's using fictitious name of Anil Ambani and took the share application. तो 447 तो एप्लीकेबल होगा ही होगा उसके अगेंस्ट, बट डिसगॉर्जमेंट भी हो जाएगी. गवर्नमेंट विल कम and he will say anyone who deals under section 38 fictitious name for share application, this person has earned any gain for the sale of securities, all the profits and gains from the sale will be taken away by the government. पूरा का पूरा पैसा जो भी उसने इस fictitious नाम से कमाया है, government can come and take the full amount from this person. Is that clear, everyone? And what will the government do? Where will they credit this amount? This amount will be credited to the Investor Education and Protection Fund. All this amount will be going. Yes, seize kar dena. Yes, 447 additionally will be applicable. Priyanka, that's correct. All right. Manish sir, somebody again with different names have joined the class. You can remove them and then lock the meeting. आप देख लीजिए उसमें आ रहा है नाम ना थोड़ा. Yes, Priyanka. So if you're trying to use any kind of false statements, that means you are using kind of abatement that you're making. Okay. So here it tries to tell you, if he makes or abates the making of the application, means he is misusing any kind of share applications with the fictitious name. Okay. All right. Now let's read this note. A person who gets the shares allotted in the fictitious name becomes liable as a shareholder. A person carrying on the business under the assumed name took shares. His trustee in bankruptcy could not avoid liability. So anyone who has been allotted the shares in this fictitious name will be held liable. Is that clear, children? So abate means to encourage. He's making or encouraging the application in this form, assisting. Everyone clear? Abate means to assist or to make or to encourage the application. Yes, Bhumika, so same 447 will be applicable if he is doing any such kind of crimes. Now let's come to section 447. We have done this. Kevin had a query in this also. So quickly tell me, I'm going to take your test of 447. What was the penalty? What was the limit that we have set for 447? What is the limit that we have set for section 447? What is the limit? Everyone has to answer me this. ₹10 lakh or 1% of the turnover, whichever is less or more. Whichever is lower. Excellent. All of you have answered it correctly. So now more than 50 lakhs. What is that? I'm just asking for the limit. Okay, whichever is less is the correct. So once you have set the limit, once you have learned the limit, then what do we have to learn? Whether public interest is involved or not involved. This was the case where the amount is exceeding and one is the amount is not exceeding. So if you are up till the limit, the fraud that you have done up till 50 lakhs and up till 5 years imprisonment. If you're exceeding and the public interest is also involved, then 3 years to 10 years. If public interest is not involved, then 6 months to 10 years will be the jail. But the amount of fraud is equal. That is, equal amount of fraud is the minimum amount and maximum is the 3 times the amount of the fraud. Now, before we move forward, I want to ask you one question related to section 36. If Mr. X offers to Mr. Y to enter into a false agreement forcefully, can you say 447 is applicable under which section? If Mr. X offers Mr. Y to enter into false agreement forcefully, he is inducing, ma'am. Section 36 becomes applicable. Excellent. Very good. Very good. Not 38, Anubhav, section 36. Okay. If X is already aware that prospectus is misleading and it is false, but still he is forcing Mr. Y to invest his money, which section becomes applicable? Section 36. Okay, another test. Where all the affected persons are filing an action suit against the company. All the affected persons, because of misstatement in prospectus, are filing a case against the company. They're filing the case together. Which section becomes applicable? Oh my God, intelligent students in my class. Almas, Soumya, Anubhav, Divya. So many students. Bhumika, Ayush, Priyanka. So many. 37. Priyanka. Nice. Good. Dhanush. Satyam case. Very nice. Section 37. तो हो गया याद सबको? Section 36, 37. Third example. If Rohit has taken the shares in a company with the name of Mr. Karan, this section becomes applicable. Rajveer Ray, excellent. All the answers, Samriti and Rajveer always first. Julie Singh, Anurid, Andri, Ayushi, very good. Ayush, very nice, very nice. Personation. Kevin, excellent. It is the case of personation. Bhavya, Kirubha, excellent. Misleading name. Very nice, children. So everyone is clear. Section 36, 37, 38, 34, 35 हमने ब्रेक से पहले कर लिया था. ब्रेक के बाद 36, 37, 38 कर लिया हमने types of prospectus and all those MCQs and question answers also we have done today. Now we are just winding up 447 and then we will move to section number 39. So 447 fraud definition we have done last time. So this was Kevin's query. Wrongful gain means the gain by unlawful means of property to which the person gaining is not legally entitled. Wrongful loss is the loss by unlawful means to which the person losing is legally entitled. Wrongful gain का मतलब होता है गलत तरीके से पैसा कमाना. Wrongful gain. Now, I did a fraud. So it says fraud means related to the company or body corporate, any act or omission that has been made, concealment of the fact committed or any other person with the intention to deceive or gain undue advantage. So any such kind of thing that you're doing, concealing in order to, sir, lock kar sakte hain aap meeting because all the good students are in the class. Yeah, done. So a fraud is when you are trying to conceal and you're trying to do any such kind of things, we are trying to gain the undue advantage of another. What is the meaning of undue advantage? Undue advantage is the term that means I'm trying to take the advantage of another person. Injure kar rahe hai kisi ko. Say for example, if I am selling you this water bottle and suppose I'm the seller and the knob of this bottle is broken. But still I have pasted it in such a way that the buyer cannot find out. Am I trying to cheat you? Am I trying to conceal the facts? Am I doing a fraud? Yes, ma'am, you're absolutely doing a fraud. So here, such kind of things where you're doing a fraud, you're trying to gain undue advantage. You're trying to take the advantage from another person. Okay. So here, if such fraud has been done, now हो सकता है मैंने ये जो fraud करा, if the bottle was 100 rupees, I sold it for 100 rupees. Then also 447 will become liable even if I have not made any gain. Okay, चाहे wrongful gain हुआ, चाहे loss हुआ या नहीं हुआ, 447 will be applicable. Whether there is any wrongful gain or wrongful loss. Wrongful gain means मैंने आपको 100 का था, 120 का बेच दिया, मुझे gain हो गया and wrongful तरीके से हुआ, legally entitled नहीं. Loss means 100 rupees का था, मैंने 90 का बेच दिया, to which I am legally entitled. So loss है ना, loss तो नुकसान ही है. वैसे भी गलत ही था तो अभी भी नुकसान हो रहा है. So in both the cases, whichever you are having wrongful gains or long, in both the cases you will become liable under 447. Any act, omission, concealment committed by a person with the intention to receive or gain undue advantage, whether or any wrongful gain or loss has been made of the company, shareholders, creditors, any other person, 447 is applicable. So this is the definition of 447. It tells you what is the exact definition of 447. Okay. Oh my God, Dhanush is saying difference between gain and loss. So difference between gain and loss is something which we have been doing since childhood, right? 100 रुपए की चीज 150 में बेची, 50 rupees gain. 100 रुपए की चीज 90 में बेची, 10 rupees loss. Now this is which what we are doing with wrongful mean. Okay. So let's read this question. Mr. Raju, one of the prospective investors under section 37. What has he done? Sue the person. Just read this question and see if you can solve. Everyone clear? Will he become liable to 447? Fraudulent misstatement was made in the prospectus. One of the investors under section 47, Angad, one of the authorized person, plead that Raju did not take any share and he has not suffered any loss. Therefore, he cannot seek the remedies for what he's asking and they are not punishable under 447 because fraud is not committed against Raju. Whether the person who has authorized the prospectus will be liable under 447 or not. Tell me. Give me a correct answer. Will the company be liable? All right. Persons who are authorized will definitely be punished because the fact Raju has not borne any loss. Wrongful gain or loss is not an essential constituent of fraud under 447. अब ये क्या कहते हैं? जिसने prospectus authorize करा है for fraudulent misstatement, despite the fact that any loss was not suffered, still the people will be liable. Why? Because he has subscribed to the securities. He has written. One of the prospective investor means who has invested can file a suit against the issue of prospectus for fraudulent mistake. He has filed a complaint under 420 of the IPC Act and 447. Angad was the authorized person. He said that he did not take any shares, so he has not suffered any loss. Now here, if you are the prospective investors under section 37, you are filing the action suit against the company. Even if no loss has been suffered, you can still file an action suit because the person who has authorized the issue of prospectus will be punishable under 447. Because 447 says wrongful gain or loss is not essential. सेक्शन 35 बोलता है आपको कि अगर आपको लॉस हुआ है तो आप कंपनसेशन एंड डैमेजेस क्लेम कर सकते हो, बट 447 तो कहाँ था? 447 तो हमारा क्रिमिनल लायबिलिटी में आता है. आपने मटेरियल मिसस्टेटमेंट करी, राइट? So section 35 was talking about your compensation damages where you have to prove. So in this respective case, yes, you can make it liable. So let's take a small break, 2 minutes break over here. You absorb the information, section 36, 37, 38, jaldi jaldi padh lo, revise kar lo, and then we are going to do a very huge section, that is section number 39. securities, children? So allotment means appropriation of previously unappropriated capital of the company. Now the time has come. We have been issuing the prospectus. We have been inviting the public to come and take up the shares in our company. Now the time has come that the company is going to allot these securities. Okay, Ajay, don't worry. We'll give you a small break in between. But as of now, we have to complete the topic of allotment of securities. Okay. So allotment means once you issue the prospectus, what do? You are giving the invitation to offer. You are inviting the public. You have not given the offer. You have given the invitation to offer, right? And when you receive the applications, children, then what it is? Then what will it become? It will become offer. Why students are not answering? Yes, then it becomes the offer. And once you allot the securities, then it becomes allotment of securities is your acceptance given by the company. So when I issue the prospectus, I have sent the invitation to offer that please come. I'm announcing, I'm coming up with the prospectus. I'm going to offer the shares to the public. You can come and send me the application. The public will send me the applications. And when I receive the applications, I have received the offer from the public. And when I allot the securities, it is acceptance. And when offer gets in touch with acceptance, it becomes the contract. So company can allot the shares to the public only when the amount stated in the prospectus as minimum amount has been subscribed and the sum payable on application has been received by the company by check or any other negotiable instrument. So when will the company allot the shares? So there are two conditions to be satisfied. Children, section 39 बहुत आराम से धीरे-धीरे समझेंगे because each and every line is very important. And we are going to do each and every word from the module also. All right. Just a second. Students. So only when you have stated the amount, the minimum amount has been subscribed. Now, children, allotment of securities is your part where your minimum subscription and minimum application money come into picture. So you have taken up the minimum subscription. First of all, let's have a quick recap of what is the authorized share capital, what is the issued share capital, and what is the subscribed share capital. Who is going to help me in understanding what is authorized share capital? Quickly. Anyone would like to answer? Nominal capital, okay, Anubhav, that is the next part. But what is the authorized share capital? The maximum amount of the capital which the company has decided to do the business for. Okay, yes, Kevin. Okay. So maximum amount of capital that has been issued in the lifetime, that is what your authorized share capital. And what is the issued share capital? What I am going to issue to the public. So I have decided that I will be issuing, say for example, I am decided to issue 10 lakh shares to the public. Now, at least 90% of the subscription I will receive, that is the minimum subscription. Yes, what the company wants to issue to the public is your issued share capital. Okay? What the company wants to issue is your issued share capital. And once they have issued this capital, then company shareholders will come and subscribe to your security. Now that subscription is the minimum subscription, which law says at least 90% of the minimum subscription I should have received. Then only I can allot the securities. Now, if 10 lakh was the issued share capital, how much minimum subscription the company should have received? Tell me. Absolutely correct. 9 lakh. Simple. So 9 lakh is your minimum amount of subscription if I have received, and whatever amount I am receiving. अब मुझे कंपनी ने शेयर्स देने हैं तो उसको क्या होगा, पैसे मिलेंगे. What is the entry? Bank account debited to share application account. Am I right? All the account students. So this money that I am receiving should always be received by way of check or demand draft. So application money which is coming to me should be in the way of check or demand draft. This is your first condition of company allotment of security. Second condition, application money जो आनी है मेरे पास. So say for example 9 lakh के shares है at the rate rupees 100. So ये 100 जो है मेरा प्राइस है. इस पे मुझे क्या मिलता है पहले अकाउंट्स. रिमेंबर when we do allotment of securities, ma'am, first we receive share application money, allotment money, first call, second call. Remember, so this is entirely your accounts chapter, what you have done in accounts allotment of securities. We are just doing the theoretical part of that thing. सबको याद आ गया. शेयर एप्लीकेशन मनी, अलॉटमेंट ऑफ सिक्योरिटीज, फर्स्ट कॉल, सेकंड कॉल. अब ये वाली जो शेयर एप्लीकेशन मनी है, लॉ सेज दिस शेयर एप्लीकेशन मनी should be at least 5% of the nominal value. What is my nominal value? 100. So how much rupees I should have received on the share application? At least rupees 5 should have been paid. So 9 lakh की subscription आनी चाहिए मेरे पास. 90% of the minimum subscription I should have received, and 5% of the minimum amount of application money I should have received. Then only I can proceed with the allotment of security. So we're going to take a small break here and then we will proceed further. All right. So everybody has read the point, minimum subscription and minimum application money. So now if I ask you that if it is written in the articles of association of a company that minimum subscriptions should be 60% or it should be 80%, then what should be the minimum subscription? If it is written that it should be 80%. Now I told you articles of association tells you about the rules and regulations, how the company is running. So whatever is written in the article of association, we will following that. But if the articles is silent, then 90% of the minimum subscription we have to consider. Anubhav has written a doubt, means 5 rupees should be the minimum amount of the share application. Yes, yes, yes. उसके नीचे सारी applications का rate नहीं हो सकता. So Anubhav, if you have not received the minimum price money or the minimum subscription has not been received, then we will not allot the securities. So the application money should not be less than 5% of the nominal value and minimum subscription should not be less than 90%. If you don't receive this, then the company is going to cancel the allotment of securities. If the stated minimum amount is not subscribed and some payable on application, what is the time period? It should be received within 30 days or any other time specified by SEBI. Okay, पहले first point में भी देख लेते हैं. Application money was not less than 5% of the nominal amount or other amount specified by SEBI. Now, SEBI tells you it should be not less than 25% of the nominal amount. So, for listed companies, SEBI has laid down the specific condition of 25%. Otherwise, for the normal companies, it is 5% of the nominal amount. I will show you in the study material where it is written. Now, this amount has to be received within a period of 30 days. So, हम 30 days ही याद करते हैं. Any other period prescribed by SEBI? So, SEBI has not told any other period. So, we have to learn the minimum amount should have been received by 30 days. From the date of issue of prospectus, तो अगर मैंने 1st October 2014 को prospectus issue करा, तो by when I should have received the minimum subscription? So, by 31st October 2015, that is 30 days period will be given to me that the amount shall be received. And if the minimum amount has not been subscribed, then you need to return that amount. Where the company having a share capital makes any allotment, it will have to file the share allotment return. Any default if you are making, the liability will be 1,000 per day or 1 lakh, whichever is less for each default. Let's try to have an understanding about this point. So the first 2 points are conditions for allotment are minimum subscription should not be less than 90% and the application money should have been received by check. If I ask you that I have received the share application money by cash, can I allot the securities? No, ma'am. Very good. So everyone is clear, minimum subscription 90% and the application money should be received by check or negotiable instrument. Now, what is the time limit for minimum subscription and allotment of security? It says amount shall be received within 30 days. कितने दिनों में amount आ जाना चाहिए मेरे पास? Within 30 days. If no allotment is made, within how many days I will refund the amount? Within 15 days. So actually it is total 45 days. First, I will wait for the 30 days to amount to come. Now, if 30 days have passed, I have still not received the whole of the amount. Then within next 15 days, I need to refund the money and the refund will go in the same bank account from where you have paid me for the share application money. And if the money is not refunded, then the directors will be held jointly and severally liable at the rate of 15% per annum. Refund shall be made in the same bank account from where the money was received for allotment. And if the money is not refunded, interest at the rate of 15% per annum will be charged. Yes, Priyanka, the same share prospectus 15 days words are written. So it is very easy to remember when you have this kind of provisions, but I would request all of you to learn this minimum subscription in the same way the chart which is shown to you over here. Because it is very important that you understand that the application money was to be received in 30 days. If not received, next 15 days you refund the money. If not refunded, then interest at the rate of 15% per annum will be charged. यहाँ तक clear हो गया? So this is your entire summary of section 39, that is allotment of securities. Are we going? No. Calls in arrears and advance is not part of this, Kevin. It is only talking about the allotment of securities. Once we have done the allotment, then you go to your accounts and you do the entries. Here we are not doing the entries. Means prospectus is valid 90 days and allotment is given 30 days. So Bhumika, that is the time period. Prospectus is valid for 90 days means 90 days का time period है उसकी validity का. After that, the prospectus is no longer valid. But once you have received your minimum subscription, application money has come, then we start with the allotment of security. But the allotment cannot be made if we have not received the amount within 30 days. So within 30 days is the time period by which the application money should have been received in the bank account. Then only we can allot the security. But वो 30 days कब से start होंगे जब आपकी minimum subscription meet हो गई. So let's see over here. It will give you more clarity, children. Minimum amount subscribed, application money has been paid and received by the company, and the application money shall not be less than 5% or this amount specified by SEBI. Minimum amount not subscribed and the application not received within 30 days from the issue of prospectus. तो कहते हैं prospectus के issue होने के 30 days में अगर हमें पैसा नहीं आया or whatever period it has specified, then within 15 days, whatever money has been received, please return it. Validity of prospectus is a different thing. 90 days के लिए prospectus valid है. हो सकता है बाद में आ जाए. 90 days के लिए तो valid है ना वो. So अभी first 30 days में अगर हमारे पास पैसा नहीं आता है तो within next 15 days we shall return the money. 15 days from the closure of the issue. Where company makes an allotment, अगर आपने allot कर दिया, अब ये second case. If you have received the money, then what will you do? Then you will allot the securities. And again, after allotting the securities, you will have to file a return of allotment and PES3 form with the ROC within 30 days of the registrar. Within 30 days, you have to file the return of allotment with the registrar. So a return of allotment shall be filed with the ROC within 30 days from the date of allotment. This is section 29, subsection 4 of the Companies Act. And if any default is made in this section, 1,000 rupees for each day during which the default continues. Now, say for example, you have received the share application money in cash and you still allot the securities. Will you forward this penalty? Yes, ma'am. You have not received the money in 30 days. You are still allotting the securities, then also penalty. You have not refunded the money in 15 days. Penalty will get attracted. You need to pay interest at the rate of 15% per annum. You're not paying the interest, penalty will be attracted. So if the penalty continues for 10 days, so the fine will be 1,000 into 10,000 or 1 lakh, whichever is less. So what is less? 10,000. So maximum fine can be up to rupees 1 lakh. So state in what way does the company regulate and restrict the following in respect of the company going for public issues. The question, now this is an examination question which we are going to discuss. But before that, I want to complete the topic from the study material also. Now children, in allotment of securities, it is for the company to decide how much security has to be allotted. And the acceptance has to be communicated. It is very important. If I have given the acceptance has been given by the company, you have to tell the shareholder that yes, we have accepted your offer and we are ready to give you the allotment. Now, if you're trying to attach any condition to that, that is conditional acceptance. All these things you have already studied about it. Okay. So it should not be a conditional acceptance. It should be an unconditional acceptance. Let me just open your study material. So this is your allotment of securities. Allotment is neither more nor less than the acceptance by the company. So it says generally whatever the acceptance has been given, that is the allotment of securities. So the first requirement is regarding the minimum subscription, at least the amount which is stated has been subscribed. So amount stated means articles of association की बात कर रहा है अभी कितना लिखा हो. And the sum payable should have been received by the company. Now here it is saying the minimum subscription is 90% of the entire issue. This is as per the SEBI guidelines. Securities and Exchange Board of India has given the regulations that minimum subscription shall be 90%. The company by which the means has to be used shall not be using the actual cash received. It will not be a valid offer. It has to be received other than the cash. Again, 5% of the amount or the amount as specified by SEBI. So as of now, the minimum amount SEBI has specified is 25% of the issue price. Okay? So the application money that you have to receive is 5% of the nominal value or the percentage specified by SEBI. SEBI generally specifies for the listed company. So if the listing company is offering the shares of rupees 10, then what shall be the share application money? अगर एक लिस्टेड कंपनी ऑफर करे सिक्योरिटीज एट 10 रुपए का नॉमिनल वैल्यू है तो फिर कितना होगा? Dhanush, this is the law that they have given that cash need receive karna. Then we cannot keep a record now. We have to keep the money in the bank account because if money will not be received, then we have to refund the money in the same bank. That's why they're not receiving cash. Okay. 2.5 rupees, absolutely correct. 25% of rupees 10 that you have calculated. Is that correct? Here you are calculating at least if the nominal value is 100, then it will be 25. So here you are, because it is a listed company, please यहाँ पे लिख लीजिए सब लोग because बाद में confuse हो जाते हो. यहाँ पे लिख लो in case of a listed company. In case of a listed company, SEBI has given the limit of 25%. Otherwise, it is 5% of the nominal value. Clear हो गया सबको? Everyone? And then refund the money in 30 days application money. If the amount has not been subscribed and sum has not been received within 30 days from the date, amount has to be refunded within a period of 15 days. Any default, 15% per annum. So you can read out it's each and everything is same. Only one thing that I wanted to tell from here is allotment of securities ki return jo jati. So return of allotment is subsection 4. It says the company has to file a return of allotment in PES 3 form. PAS 3 form. And within how many days? Within 30 days. What all is to be given in the return of allotment? A list of allottees. अब आप return of allotment file कर. आप उसे बताओगे भी ये वाले allottees हैं जिनको हमने shares allot करे हैं. इतनी securities allot हो गई हैं. What have you actually done? You have allotted the securities. Now you have to send a return in PES 3 form with the ROC that these are the allottees with the name, address, and occupation and number of securities allotted to each allot. All right. A company other than a listed company, all the stock exchange which are listed shall be attached to PES3. The valuation report will also be taken. So if you are a listed company, then you have to attach the valuation report also along with your return of allotment. And this penalty also we have done. So now without cheating, everyone is going to read this illustration and send me the answer in the chat box. Everyone is going to do it. Read the question very carefully. Everyone is supposed to read it. %80 has been stated in the prospectus. So is it correct? Only 3 answers. I'm waiting for all of you to answer this one. Read it very carefully, children. All right. So everyone has given the correct answer. It says 80% of the amount was stated. Before finalization, he has withdrew 50% of the said amount from the bank for purchasing certain assets. Now, there is a company which is before allotting the securities, you have. Can you use someone's amount without allotting the securities? Can they do that? It says now it started allotting the subscribers, and Rashmi, one of the subscribers who was allotted 1,000 shares, she refused to accept the allotment and said that the allotment is void. It has violated the provisions. What do you say, children? Is it correct? First of all, 90% okay. So 80% you have accepted. Good. Within the prescribed time. All right. All right. Absolutely correct answers given by all of you. Let's try to understand those who have not understood. So here the company has received only 80%. So minimum subscription should have been 90% because it is not mentioning about the articles. It has received 80% as stated in the prospectus. So here the minimum amount has not been received. So allotment is not as per section 29, which prohibits a company from making any allotments until the amount has been received. So the company is required to refund the entire 80% of the amount received. Rashmi is within her rights to refuse the allotment, which was illegally made by the company. And also, children, see the company is withdrawing the amount for the purchase of certain assets. So this cannot be done. Company will be held liable. Action will be taken against the company. So enjoy doing it. Let's do certain questions. Fatapat se. Let me see how many questions we can do. Okay. Now read this question and send me the answers in the chat box. In what way the company regulates and restricts the allotment of securities for minimum subscription and the application money payable on the shares? Very good, children. So no allotment will be made unless the minimum amount has been subscribed. That is 90%. The sum payable will be 5%. If I ask you, do you have to write about the 25% provision? So you simply say that, ma'am, application amount will be not less than 5% or the amount specified by SEBI. No need to mention about 25%. तो आपने लर्न करने के लिए क्या लर्न करना है 90% वाला लर्न करना है मिनिमम अमाउंट ऑफ सब्सक्रिप्शन और द अमाउंट स्पेसिफाइड बाय सेबी एंड एप्लीकेशन मनी में आपने 5% वाला याद करना है और द अमाउंट स्पेसिफाइड बाय सेबी. If the amount is not received, return it within 30 days. If it is not received, refund it within 15 days. Penalties 15% per annum interest and penalty of 1,000 will be charged. So Anubhav, Priyanka, Bhumika, Rajvi, Ray, Samriti, Kevin, Shelja, Judy Singh. Oh my God, so many students. Mausam Kumari, Soumya, Almas, everybody have sent the correct answers. So wonderful students. That means you have understood it very nicely. And this was a very important topic. So I understand you get tired in between because we have done so many sections and it is technical, but the best part is that you all are answering it nicely. If the company does not accept the application, yes, Soumya, company has the right to reject the offers also. But I told you one point related to indoor management. If company is intentionally trying to do something wrong. Say, for example, company का कोई resolution था जो pass होना था, then only the allotment can be done. Now you cannot make the outsiders suffer because of your internal allotments, internal resolutions have not been passed. In that case, the company can still be held liable. So once your minimum subscription and application is confined, if the details are met, then the company has to lock the securities. But again, if you have subscribed for 500 shares, then it is up to the company. That company को लगा मुझे सिर्फ 300 देने हैं, 200 offer reject करनी है, the company can do that. Okay, so company can reject the offers also. Thank you so much, Bhumika, for writing. All the concepts are crystal clear. I'm so glad to read this. Chapter note, Priyanka, I have not taught you chapter 2 notes, so I cannot give that. I will upload chapter 3 notes. I will give to the technical department and they will upload it. Okay. Chapter 1 has already been uploaded over there. All right. If you have any doubts, you can ask children. We are well in time, completed all the sections as planned for today. If you have any doubts, you can ask. Thank you, Abhinav. Yes, Soumya, it has to be 5%. Thank you, Mausam Kumari. I'm glad you enjoyed the session. Ajay, your next class is on 2nd April with me. We'll be completing the chapter of prospectus. We are left with section 40, 41, and 42. All right, so we will be doing a very big section again, the same day private placement. Do come prepared with all the sections that we have done today, because again, I'm going to take a quick test while you join the class. Yes, Ajay, you want to ask something? You can type it in the chat box. We're not supposed to unmute now. If you want to ask, you can ask in the chat box. All right, no queries, children? Everything is clear? Yes, Jendra, it is 50% minimum, not 50%, it is 90%. Okay, thank you. Kevin says all the concepts are clear, so that's great. So children, one thing you have to do is, today just read all the provisions that we have done. Yes, Subhanshi, you have to check those assignments because we have already done similar kind of questions. So just try to solve them. That is for your benefit. We have given kind of a test, okay? So what you have to do is always try to solve all the questions given at the back of the study material. Study material के पीछे जो questions दिए हैं, Institute has made so much effort. They have written down the answers for all of you. Okay? So you should try practicing them. Try writing down the answer by yourself first and then try to cheat it from the book, how you have to present it. Clear ho gaya sabko? Okay, thank you. Kevin is saying I'm a foundation student and I'm taking your session so well. Thank you so much. All right. Thank you, children. Now I can only see all the thank you notes and messages coming up. So that means no more queries from your side. So we can, it's okay, Ajay, if you have any doubts, you can write in the chat box. Writing practice, yes, Priyanka, you should start doing it. And while we are doing the case studies, keep marking all those things that I keep telling you about the provisions, facts of the case and conclusion, okay? So again and again, when you keep practicing, the fear will go by itself. All right. Let me just check. All right, sir. I think we are done with the session and I can only read the thank you messages now. Yes, sir. Thank you, sir.